but I uncovered been going through a list of the individuals that were incarcerated with this defendant when he was locked up back in '98.
The defense and our need for an investigator to be able to talk to these late identified witnesses by the state, so that we have an opportunity.
This case will be my life for the next 5 weeks. So.
Rob, tell me about today.
Well, she heard evidence on Friday in regards to a motion to suppress that the defense filed in regards to a purported in custody statement, audio and written, that the defendant gave back in 1998, and she made a finding that the rules that the officers not acting in bad faith at all didn't follow the procedures set forth in the family code. So we respect the court's ruling, and we will be ready for trial on February the 2nd.
How does this affect your we
It doesn't affect it at all. We will put on the best case we can. We're still working hard at gathering evidence, and the officers that have worked in this case over the years and now have worked very hard, and we will continue to do so.
Those 20 inmates that you mentioned in court, are those from just in 1998 or over the course of time since you've been locked up?
Brandon, it'll all flesh itself out. During the certification hearing, the court heard some evidence that the defendant had allegedly been talking to other people about what had happened out there, so we're following up on that lead.
Okay.
Thanks.
Very quick appeals for him, I think. Tell me what you bring to him.
Yeah.
Okay.
Well, just just tell us what happened today, and just kind of your reaction to getting that motion granted.
Well, we're fortunate to be in a court where the judge takes a great deal of time to read the law and also the motions of the state and also the defense, and we briefed this case really well. And the court understood exactly what the case law says, and that is that this statement was obtained in violation of protected statutes. So the court really had no option other than to follow the law and exclude the statements.
How much difference is it going to be in your case? Easier, harder, anything like that?
I don't think it makes the case that much different, really. The statement that was obtained didn't have very much to it. It certainly didn't implicate my client. This statement was reviewed back then, and it didn't bring forward a prosecution, and it didn't add anything additional to the case, but it needed to be excluded.
And this information about the inmates from the other jails, how is that going to kind of come into play for your next few weeks of planning for the trial?
Well, my opinion would
delay
be,
the trial.
well, no, the case is going to go to trial. The judge is going to be very strict with us, but this would be standard procedure for the state to try to get some kind of snitch to come in and say that my client did it. And they're going to have to rely on something like that because there is no actual evidence that my client committed this offense. So everything's going to have to be innuendo, emotion, and hearsay. And our position is there wasn't evidence to prosecute this case back then, and there certainly isn't evidence now.
All right.